Hi, my name is Zach McGee. I'm the chairman of New Media Legal Publishing, the sponsor of this CLE program. The presenter of this program is Andrew Struve. Andy was a brilliant, experienced, and highly successful litigator here in Southern California. On a personal level, he was also a warm, caring, and infectiously funny human being. Sadly, Andy passed away in July 2023 after a brief illness. The program you are about to watch was recorded a few years ago, but I've confirmed that the content still reflects the current state of the law on this topic. Reposting the program allows lawyers like you to continue to benefit from Andy's wisdom, and it allows those of us who knew Andy well to keep him around us for at least a little bit longer. I hope you enjoy it.
Hello there, my name is Andrew Struve. I'm a trial lawyer coming to you from Southern California. And our program today is on ethics. It is a 1-hour presentation. It's designed to satisfy the 1-hour continuing legal education requirement of the jurisdiction or jurisdictions in which you practice. Just a brief introduction to what we're going to do here today. I have attended many such ethics programs over the years. And one thing they all have in common is they can be quite boring. We're going to try to do something a little bit different today, and we're going to look at some famous and some not so well-known instances of attorney discipline and the circumstances from which they arose. There are written materials for this course. They are required, and what we've done is provided a scorecard. And on that scorecard, we've listed around 20 or so different provisions excerpted from the Code of Professional Conduct, which are sort of generally applicable rules, although they may differ in some respects from one jurisdiction to another. I think they'll be universally applicable to the circumstances that we'll go through today. So you are invited to play along and score each of these people we'll speak of, and put a little check marks or happy face or whatever you like in the column corresponding to them. And if you're in a group, that makes it even more fun because you can compare notes later. I'm not going to present these people in any particular order, except that I'm going to try to vary them a little bit according to what they did in the backstory. There are, however, a few individuals who, because of their role in history, sort of naturally go together, and you'll know that when you see them. You may have guessed before you started watching this some of the people who will be mentioned. You'll probably get some of them right. You probably won't have heard of some of them. A word about selection. In assembling the people to discuss, I made it a point not to put up anybody whose events are still very fresh in the public news or the public mind. I have tried to select people where history has had at least a fair chance to judge their conduct, and the concrete, shall we say, has hardened on their case. So you won't be hearing anything straight out of yesterday's newspaper, and that's for good reason. The second thing I've attempted to do is to select people where the disciplinary process has already run its full course, or at least where the criminal process upon which the discipline is based has run its course, at least through the stage of an indictment, because it's not fair to the people to present them as examples of what not to do unless the facts are fully baked. You will notice a bit of a skew in gender of the people we discuss. I wanted to assure you that that's not due to any bias on my part. You will find it skews overwhelmingly male. I will leave it to the social scientists to decide what the cause of that is. It could range, just speculating, from the fact that at the periods of history in question, most of the lawyers were male. It could stem from the fact that males are more liable to ethical breach. I don't really know. You do find these biases in crimes. Males are overwhelmingly more likely statistically to engage in violent crime. That's just the way the statistics bear out. But I wanted to make it a point that there is no gender bias here. And with that, we'll kick off, and there'll be a picture up on your screen. This is Vice President Spiro Agnew. This is Richard Nixon's first of two vice presidents. He was first announced as Nixon's running mate at the Republican National Convention. This would have been 1968, when Nixon was nominated for the Republican Party. And Agnew at the time had been governor of Maryland. He was a former Baltimore County executive. He'd been in the private practice of law periodically in his early career. He came out as a hardliner. He came out as a conservative. At the time, if you either recollect or might be surprised to imagine, Nixon was known as a moderate. And Agnew kind of balanced that. Nixon also used him as kind of a hard-hitting person who would say the things that Nixon didn't wish to, like several others in that administration. Well, there was a problem. During the period of time that Vice President Agnew had been Baltimore County executive, and later during the period of time he was governor of Maryland, he was found to have engaged in accepting bribes for the awarding of First County and then State of Maryland contracts from a variety of contractors, asphalt, paving, construction, that sort of thing. And one of the people from whom he accepted bribes was a gentleman named Lester Matz. Matz was a large contractor in the Maryland area. He apparently anticipated that something like this might have occurred, and so he kept detailed evidentiary records against Agnew that he could then trade for leniency in the event he were ever caught. And indeed, that's exactly what happened. And starting in 1973, you'll recall that Nixon resigned in the middle of 74. Agnew was investigated for corruption. He was found, according to the proffer of evidence that was made, that Matz and others had been paying Agnew 5% of the face value of all contracts awarded, which is a fairly spectacular kickback when you think about what a public works contract costs. Indeed, the bribes not only continued during the period of time that Agnew was governor, they also continued during the period of time that he was vice president. Part of Matz's proffer to the government was that he'd paid cash bribes to Agnew on at least 3 occasions, actually physically within the White House. And Agnew ultimately pleaded guilty to a single felony charge of tax evasion, and as we know, resigned the vice presidency. Nothing to do with Watergate at all. And he was replaced at Nixon's selection, confirmation by Congress, by Jerry Ford, who proved to be a pretty good selection for events that everybody knows about. Agnew apparently, after he was convicted, he moved to Ocean City, Maryland. He wanted to engage in the private practice of law again. And that effort was rebuffed by the Maryland Court of Appeals, which disbarred him in 1974. And in the written decision disbarring Agnew, the court called him, and I'm quoting, morally obtuse. So, and with that, we'll put Mr. Agnew back in the history books. Our next candidate is John Mitchell. John Mitchell is truly a story unto himself. He was the Attorney General of the United States during the latter part of the Nixon administration. He had a very interesting life. His personal life, his marriage to Martha, was interesting to say the least, and bears investigation of its own. She was a very outspoken, colorful person. Mitchell himself was not quite as colorful. He'd practiced law in New York from 1938 until 1969 as a very successful municipal bond lawyer. he invented something called a moral obligation bond, which was not actually backed contractually by the state of New York government. It was more like a promise to pay, almost take it on good faith. And so why would somebody issue such a bond? Because it was an ability for the state executive branch to avoid having to secure legislative or voter approval of the issuance of such a bond. So these were moral obligation bonds. Anyway, moving on to the White House, he was ultimately convicted for a role in cover-up of the Watergate scandal. He was found guilty of conspiracy, obstruction of justice, and perjury. He was sentenced to 2.5 to 8 years for participating in that cover-up. He was sentenced by Judge Sirica. He wound up serving only 19 months of it. But he apparently, one of the findings of fact underlying the conviction of guilt was that he had not only participated in the cover-up of Watergate, not only had at least 3 meetings, documented meetings with then President Nixon relating to the cover-up, but indeed had actually personally been one of the planners of the break-in of the Democratic National Committee headquarters in the Watergate Hotel. And that's the sad end of John Mitchell's career. Roy Cohn, our next nominee, had a very storied career in American life. And this is one of the interesting circumstances where the grounds for the ultimate disciplinary action against the lawyer were unrelated to some of the most famous things in which he'd had a hand. Roy Cohn has widely been regarded as the mentor of at least one quite well-known current political participant. He's best known to history for being the chief counsel to Senator Joseph McCarthy's investigation and his special committee on communism in the U.S. government and in various other aspects, such as the Hollywood film industry. Cohn had a fine educational background. He'd attended Columbia University. He worked in the U.S. Department of Justice, and he was the prosecutor for the Rosenberg trial, the trial of Julius and Ethel Rosenberg, who were suspected of being spies. That trial unto itself has been the subject of many books. There's a lot of discussion about whether both of the Rosenbergs had indeed participated in the conduct that was charged. That bears investigation of its own. It seems fairly likely that they were not both guilty as charged, but they hung together and they both died in the electric chair. Cohn, in later life, he went on to be a mentor of our former President Donald Trump, and he had a lot of high-profile clients. He was known for being quite an attack dog, and the controversy concerning his, it really dogged him through his entire career. He first became an assistant U.S. attorney in the Southern District of New York. Later, there were allegations that he'd used family connections to obtain that role. He'd gone on prosecuting in that office. He prosecuted 11 different alleged members of the American Communist Party for plotting allegedly to overthrow violently the U.S. government. In 1951, he goes over to the Rosenberg trial, and later said that the death penalty was imposed by then U.S. District Judge Kaufman based on Cohen's personal recommendation, which would have been an ex parte communication, and I don't know of any independent evidence that would have supported that. It is fairly well settled, though. The Rosenberg trial was marred by quite a few judicial and legal improprieties. The feeling today is they certainly should not have been executed based on the evidence. Harvard Law School professor, still Harvard Law School professor, Alan Dershowitz wrote that the Rosenbergs were both guilty and framed. So, again, we'll leave that to history. After leaving the McCarthy Commission, Cohen went on to a 30-year career in private practice in New York City. Clients included Donald Trump, George Steinbrenner, Aristotle Onassis, Tony Salerno from the New York mob, Carmine Galante, John Gotti, but also Studio 54 owners and one-time hotelier Steve Rubel and Ian Schrager, represented the Roman Catholic Diocese of New York, and quite a few others. But unproven allegations that dogged him through his career were repeated claims of theft, obstruction, bribery, blackmail, fraud, perjury, and witness tampering, at least per the popular press, again, unproven allegations. What is, my notes remind me that Mr. Cohen also served as an assistant to Roger Stone in the Reagan presidential campaign in 1979, carrying over to 1980. Allegedly, Cohen had a role in helping Roger Stone, who's been in the news here in recent times. Allegedly, Roger Stone cooked up the candidacy of third-party candidate John Anderson in the 1980 election in order to take votes away from the Democrat candidate. And although not illegal, that certainly is an interesting bit of manipulation of the political process. There were federal investigations in the 1970s and 80s. Cohen was charged 3 times with professional misconduct, including perjury and witness tampering. And he was accused in New York City of financial improprieties relating to public contracts and also private investments. And he was acquitted on all charges. Character witnesses included Barbara Walters, F. Lee Bailey, and Donald Trump, all of whom basically repeated he had a great reputation and supposedly incredible integrity. Well, in 1986, Cohen was disbarred by the New York State Court of Appeals. So he was disbarred from practicing in the state of New York. And what's fascinating is none of the events that we've just spoken of are what caused that disbarment. What did cause his disbarment was an allegation that necessarily was found to have been proven for purposes of the disciplinary action, that in or about 1975, he had a client named Louis Rosensteel, and that he had gone to the hospital room of a dying Mr. Rosensteel, and a multimillionaire founder, industrialist, and coerced, persuaded, forced, the adjectives have varied, Rosensteel into signing a will conveying his many $million personal fortune over to Cohen. And most of our audience today are members of the bar, and, forcing, coercing, or even, frankly, by the way, even allowing a client that you're representing to give you property raises enormous ethical considerations and implications. And in any event, Cohen did this. That was a finding of fact made by the New York State Court of Appeals. And during the evidentiary part of the discussion, the court determined that the purported signature on the will was indecipherable and in no way a valid signature. And so Cohen was disbarred for the remainder of his life. Our next candidate needs no introduction, Richard Nixon. Many things have been said about Richard Nixon. One of the lesser known facts about Richard Nixon is that he's the reason that you're watching this presentation today. almost everybody who's still in practice has taken the multi-state professional responsibility exam. It's separate from the state bar exams. When I took it, it was 50 questions. It may still be, I'm not sure. The multi-state professional responsibility exam, and indeed the ethics component of continuing legal education classes, you owe your thanks entirely to Mr. Nixon. There was no such requirement before his resignation from the presidency. And much like those of us in the state of California who are required to take a biannual class on prevention of workplace discrimination and harassment, have our former Governor Arnold Schwarzenegger to thank for that requirement. Your time today, you owe a silent thank you to former President Nixon. Nixon was born in Yorba Linda, California. He used to say he was born on a lemon farm, and it was the poorest little lemon farm in the area. Nixon had a tough childhood. His father, Frank, was a hard man. His mother doted on him and his brothers. Nixon had a brother who died of tuberculosis at an early age. He'd been sick most of his life. It was a real burden, frankly, on the entire family and probably on Nixon. And social scientists will say that something bad must have really happened to Mr. Nixon early in life, and I think that might cover some of it. Anyway, he was from Yorba Linda. He went to college down the street at Whittier College, about 15 miles from Yorba Linda. Was an absolutely pathetic member of the college football team, but apparently never quit. And then he went on to Duke University School of Law, returned to his native Whittier, and became a member of the firm that most recently, if memory serves, was known as the Bewley-Lassipin firm in Whittier, well regarded, still in existence today, and sort of the crevasse, Swain and Moore of Whittier, California. Whittier is a pretty small town. And so from then, Nixon's career is reasonably well known to all of you. You'll recall he served as vice president under General Eisenhower. He went on to run for president in the 1959-60 campaign against Kennedy, which he barely lost. Some people will say that he didn't lose it. What he did do is resign graciously and not dispute the vote counting in certain jurisdictions where, if scholarship is to be believed, it certainly could have been disputed. After losing the 1960 presidential election, he attempted to rehabilitate himself politically. He dabbled again in the practice of law. He was urged to run for governor of California in 1962 against then Governor Pat Brown, the father, by the way, of twice California Governor Jerry Brown. And so Nixon ran against Governor Brown, and he lost. And following that loss is when he gave his famous concession known as the Checkers speech, where he said that it was his last press conference and nobody would have Dick Nixon to kick around anymore. Well, he came back. If there's one unifying theme to Nixon's life, it was his ability to rehabilitate himself, at least to some extent, both politically and certainly financially, and to a certain extent in history's eyes. After losing the California governorship contest, Nixon moved to New York, and he joined a fine firm then known as the Mudge Rose firm. Somewhat characteristically for Nixon's ambitions, part of the deal he made to join was that the firm was named Nixon Mudge Rose when he was there. And then some other partners' names, actually Nixon, Mudge Rose, Guthrie, and Alexander, as I recall. Everybody knows the circumstances of Watergate, and people are familiar with the circumstances surrounding the fact that he was called upon to testify by Judge Sirica in the impending trials of certainly George Mitchell, and if memory serves, John Dean, perhaps Gordon Liddy, I'm not sure on that one. Nixon, of course, resigned the presidency in favor of Jerry Ford, whom you'll recall got the vice presidency by the resignation of Spiro Agnew, who we discussed earlier. Then Mr. Ford got the presidency upon the resignation of Richard Nixon in 1974. And so Ford became a president who had not been elected to either seat. Nixon was subsequently disbarred after leaving office. In 1976, he was disbarred, again by the New York State Bar Association, subsequently by the State Bar of California. Generally, each state bar has a sort of reciprocity provision wherein if a lawyer is found to have engaged in conduct requiring professional discipline, and such discipline is imposed in jurisdiction A, jurisdiction B will then ride in on that conviction and make a similar finding. That's certainly what happened in Nixon's case. A lawyer who is subject to professional discipline, as you may know or recall, is afforded an opportunity. They're afforded administrative due process to present evidence, to be heard, to present explanations, and as oftentimes happens in discipline cases, Nixon chose to present none. I don't know what his reasoning was, and I haven't read any account of it. Probably his thinking was that there was nothing he could do to improve his position, and the more press attention that his circumstances of Watergate, notoriety gained by it, 1973, 1974, the resignation, the Ford administration. Well, after the pardon, he probably was of the opinion that he'd had enough relitigation of that issue, and that led to the David Frost interviews, the Frost-Nixon tapes, the series that was published, the incredibly lucrative book contracts for his memoirs, and leading to his rehabilitation, at least to a certain extent in the eyes of history, to a focus, rightly so, on some of the things that he really did achieve. He was obviously a deeply tormented man and suffered greatly. And certainly the loss of the presidency must have been driven him partially to that. He chose to become a senior statesman, a senior scholar. He wound up speaking 10 years after his resignation at the Republican National Convention, where he was received with a standing ovation. He served as a counselor and advisor to later presidents, and by all accounts acquitted himself well on behalf of the public. But he never made an attempt to regain his license to practice law, and it's uncertain what such an attempt would have led to. Our next topic of conversation is a lawyer who, the last time I checked at least, which was recently, is still alive. A New York lawyer named Bert Pujosh, I'm not sure how he pronounces it. He was practicing personal injury defense law in New York in the 1950s. And in 1959, I believe while married, yeah, he was married and he had a daughter, he began a relationship with a 21-year-old woman named Linda Riss. When Linda Riss discovered that Pujosh was married and had not informed her that fact, she broke off the relationship, and Pujosh then threatened to kill Riss, allegedly told her, quote, "If I can't have you, no one else will have you, and when I get through with you, no one else will want you," end quote. Riss reported the threats to the New York City Police Department, which led nowhere. Linda Riss then got engaged to another gentleman, And upon hearing this, Pujosh hired 3 men to attack Riss. They threw lye in her face. They left her blind in one eye, completely blind in one eye, nearly blind in the other eye. Her face was hideously scarred, or at least permanently scarred, one would say. Pujosh was convicted of this crime, spent 14 years in prison, during which he repeatedly wrote to Riss. The story would be horrible but less interesting if it ended there, but it didn't. When Pujosh was released, he and Riss resumed a relationship. They married each other, and they were married for decades until her death from natural causes, I'm afraid I must add, in 2013. Pujosh had been disbarred following his conviction for what must have been felony aggravated assault or whatever, and conspiracy and many other things. Our audience can figure out what to charge that with. It wouldn't be tough to figure out. But in any event, he was disbarred following that violent conduct. He subsequently, after release, marrying Riss and rehabilitation, gained reinstatement of his license to practice law. So it's a heck of a story unto itself. It's the subject of a book called Crazy Love and a documentary of the same title. After his release, their marriage and obviously reconciliation predated the marriage. One would find them occasionally on local talk shows. It goes without saying that Riss still bore the marks of the attack, as she did for her entire life. But they would make appearances. By all reports, they lived as a happily married couple. I have no reason to dispute that. It takes us to an interesting issue in terms of the fact that some of the lawyers we've spoken about earlier have been disbarred and not attempted rehabilitation, and their crimes were monetary or otherwise fraud on a client or that sort of thing, or fraud on the government. And Pujosh, it's an example of a crime of violence, right? And actually it's easier to get professionally disciplined for a crime of fraud or other monetary misconduct than it is for a crime of violence. The way the courts and the case law developed from the courts view it is that an act of violence is open and flagrant. It's not an act of deception. That an act of deception somehow is more automatically worthy of professional discipline. I leave that, to your own moral compasses and your own judgments. I think any one of us could have a perfectly spirited debate taking either side of the argument. I will say that, at least in my home state here of California, if you are convicted of felony theft of funds from a client, and if the lawyer next to you is convicted of an open, not hidden, right, crime of, say, voluntary manslaughter or second-degree murder, as long as it's not against a client, as long as there are not enhancing circumstances attending that killing, the lawyer sitting next to you is much more likely to be reinstated to the practice of law after, I'd say, paying their debt to society, but that in itself is a moral judgment, and I'll reserve that to your own decision making. But the last time I checked, and it was some time ago, we had at least several convicted murderers who are licensed and active members of the California State Bar after having been rehabilitated. Harder to do if you steal a lot of money from a client. I think one of the underlying themes that you'll find from these stories is, I suppose, at the first and most obvious level, the value that the bar places in public confidence in lawyers, and usually acts done against a client are much likelier to provoke the ire of the bar than acts done against non-clients. We say the bar is a self-policing professional organization, and I'm speaking of all states generally at this point. We say it's a self-policing organization. One of the things it polices is the collective reputation of its members, and conduct by an attorney that undermines public confidence or faith in the bar is punished pretty swiftly and effectively, because it's no surprise, for example, that a lot of times when you look at various state or federal laws, you'll find them fairly protective of lawyers. And after scratching your head for a while, you'll say, well, there's more lawyers who are members of Congress than members of Congress who aren't lawyers. So go figure. It's funny how that works itself out. On a broader scale, without getting too philosophical, the justice system exists to provide a redress of grievances to prevent people from killing each other over disputes. And if people don't have confidence in the justice system, they'll resort to their own methods, which devalues things that society cares about, such as consistency and value of property and that kind of thing. And if one doesn't have confidence in lawyers or judges, that contributes to disrepute of the legal system and distrust for it, and then vigilantism. And social scientists amongst you can make many of the same statements about the political process and about confidence in elections and the effect that it can have on our collective strength. I'll leave that for another speaker, and plenty of others have talked about it. Well, after Bert Pujosh, we'll go back over 100 years, just very briefly. Up on your screen right now, if we did this right, is former United States Southern District of New York Court Judge Martin Thomas Manton, federally appointed judge in the state of New York. And he'd been a district judge, then he went on to be elevated to the United States Court of Appeals for the Second Circuit, which is kind of a big deal. He was born in 1880. He was a graduate of Columbia University Law School, was put on the court in 1916, and only 2 years later he was elevated in 1918 to the Second Circuit. And he was even considered later by President Harding for nomination to the United States Supreme Court. Manton had a number of published decisions over his career as a judge on the Second Circuit. These days, I was told once by a then United States District Judge in the Southern District of New York, he was flipping through a paper and then he said, you can always tell when a lawyer is not from the Southern District. The Southern District is called, among other things, the Mother Court. It's one of the oldest, if not the oldest, of the federal district courts. The Southern District has always had a very storied reputation for its reasoning and its rulings, and they have a reputation of truly taking care of their own judges and justices alike. I had the good fortune of being friends with a gentleman who'd served as chief judge of the United States District Court for the Southern District of New York, and served there for decades and decades. And the court staff is very tight, I'll put it that way. Well, the judge that I was talking about at the time with reference to former Court of Appeals Judge Manton was flipping through papers and said, well, you can tell a lawyer's not from the Southern District. They cited an opinion by Judge Manton. And intrigued, I said, well, who and so what? Well, it turns out that there is an unspoken rule among the judges in the Second District Court of Appeals not to cite cases by Judge Manton, and at least for some of the older ones, to sneer a bit at litigants who do cite cases by Judge Manton. And the reason, unfortunately, is that Manton lost a great deal of money during the Great Depression. He reportedly had a rather lavish lifestyle. He began taking gifts and loans from persons who had business before the court, and allegedly that degenerated into accepting outright bribes to decide cases in favor of the bribing litigant. In 1939, then Manhattan District Attorney Thomas Dewey, later Governor Dewey, later founder of the Dewey-Ballantine firm, storied firm, pressured Manton to resign. Manton did indeed resign. However, the Second Circuit Court of Appeals, on which Manton had sat, convened en banc, along with U.S. Supreme Court Justices Sutherland and Harlan Fiske Stone, and convicted him for bribery, multiple felony counts, and he served 17 months of a 2-year sentence in federal prison. There was a controversy, I remember, some decades ago. All the judges, the Second District Court of Appeals is a coveted and highly respected position, and at least until the last time I was looking at the situation, there was a huge gallery of oil paintings of the judges of the Second District, and Manton's painting had hung there for decades after his removal and criminal conviction. The painting was subsequently removed. If I knew the circumstances of what prompted it, I'd tell you, but I don't. But you can infer what must have happened. And subsequently, the painting apparently was appropriated by another judge of the Court of Appeals who kept it hanging prominently in his own chambers. I'm not going to say who. But anyway, interesting facts about Manton. A tip from the wise: don't rely on his opinions in the Second Circuit. Just kind of put them off to one side. We have a practice in the state of California. The Supreme Court can engage in a practice, very controversial practice, topic for a different discussion, of depublishing opinions. Unofficially, with no order, but just by sort of judicial reprobation, the Second Circuit has effectively depublished the Manton opinions. Our next subject of discussion is a truly interesting character, Attorney Mark Dreyer. We're now skipping forward almost another century. Mark Dreyer was a New York City lawyer. He'd been with several large firms in his career that will remain nameless because they don't deserve to be named. They did nothing wrong to my knowledge. He became co-chair of litigation at one such New York firm. And then he ultimately opened his own practice, teaming up with a few well-known lawyers, and formed his own firm, like I said, and opened offices in New York starting in 1999, and in Boca Raton, Florida, and other places. One of his practice areas of choice was plaintiff-side class action work, which obviously is highly remunerative if you do it correctly. Dreyer was a high flyer, for those of you who hadn't heard of him. He bought a house in West Hampton, had a house in Quogue, then he bought the house next door to the house in Quogue, then he bought a yacht for $18 million with a crew of 10, docked it in New York and St. Martin, supposedly billed it to the law firm, thanks a bunch. Had a waterfront house, a Manhattan triplex, a penthouse on Ocean Avenue in Santa Monica, and. His New York office evolved into a lavish office at 499 Park Avenue. When his assets were ultimately liquidated, you can guess what happened here. They included Picasso's and an original Andy Warhol portrait of Jacqueline Onassis, which is one of the more prized Warhols, along with the Maus and the can of Campbell's soup. The fascinating thing about the Dreyer law firm, it had very high revenues for a firm of its size, and it commanded a good deal of respect for the time that it was in operation. It had only one equity partner, Mark Dreyer. It had an entirely closed compensation system. Dreyer controlled all the firm's finances. He handled all the administrative functions. There were no executive committees, and there were no partnership meetings. I had heard a rumor that he reset all the quote-unquote partners' compensation quarterly, entirely at his own discretion. Certain people thought that was terrific because, kind of like being a college football coach, you are rewarded immediately for your successes and doubtless punished immediately for your defeats. So again, some people thought that was a terrific way to handle senior lawyer compensation. Other people, frankly, were horrified by it. But the real horror was yet to come. It later came to be found out that despite the many successes, the Dreyer firm was operating at a deficit of about $1 million a month. One of its senior partners died on the job from a heart attack in 2009. And Dreyer was ultimately arrested. He had apparently been engaged in money laundering. He was indicted in 2008 and 2009, I should say. And he supposedly swindled approximately $380 million from various hedge funds, selling completely worthless financial instruments, and often engaging in forgery. If I remember correctly, he was ultimately arrested for being up in offices. And my apologies if I have them wrong. I believe he was attempting to pass off around $500 million worth of false securities to the Royal Bank of Canada. Evidence suggests that his theft through securities fraud may have ranged as high as $700 million. There are people in the industry who will suggest that some victims of securities fraud, particularly if they're funds, never admit the securities fraud, particularly if they think that they are unlikely to recover financially. In the investment community, the ability to function as a fund relies obviously on the trust of your investors and your judgment and management. And so nobody was rushing up to the window to admit to being a victim of Mark Dreyer. But he ripped off pension plans, the Canadian pension plan. Oh, he stole $400 million from the client escrow account. Oops. And he had the bad luck to be following the sentencing of Bernie Madoff by around a year, maybe a little bit less. Prosecutors had asked for a 145-year sentence. Judge Jed Rakoff of the Southern District of New York rejected that. If you'd like opinions on Judge Rakoff, I'd refer you to the general press. They are wide-ranging and varied, but one thing I don't think the judge has ever been accused of is being uncertain of how he believes in something. He has a deep belief in things, and he was of the opinion that Dreyer's conduct did not rise anywhere near the level of Madoff's. Dreyer was sentenced to 20 years. Those of you who practice in the criminal courts may know that unlike many states, a federal sentence, you actually get to serve most of it. And Dreyer's up for release, if I remember correctly, in 2026. It goes without saying that, of course, Mr. Dreyer was disbarred. Going along the list of things that you could do wrong on the scorecard that we've given you, you're going to run out of pencil before you run out of boxes to check on Mr. Dreyer. So our next candidate is a lawyer named Joel Steinberg. Truly a sad story, but from an ethical standpoint, it's hard to imagine somebody that could have engaged in conduct more deserving of discipline, or a conduct that truly is worthy of condemnation, frankly. And again, you can sort of check the boxes on everything this gentleman did to his clients and others. Mr. Steinberg was a criminal defense attorney in the city of New York, and raised in the Bronx and Yonkers. Fordham University Law School, served as an officer in the United States Air Force following that. Didn't have to take the bar exam because he'd been conscripted into the U.S. military service during the Vietnam War. There was an exception during the Vietnam War, exception of the requirement for the exam for lawyers who were conscripted into service, and he was one of them. And it's reported that in or about 1981, while practicing in New York City, a client of Mr. Steinberg's had retained him to locate a suitable adopted family for the client's daughter, a baby at the time named Lisa, and Attorney Steinberg agreed to take on that representation and find a suitable home for Lisa, adoptive home, and later reported to the client that he had done so, although he did not provide supposedly any details of the adoption. 6 years later, in 1987, this is a finding, not an allegation, Steinberg was under the influence of crack cocaine and beat Lisa to death in his home. She lingered for 3 days, ultimately died. Steinberg's girlfriend turned evidence against him, and in exchange got an agreement not to prosecute her. There was a 12-week trial. Steinberg never expressed remorse for the killing. In fact, his defense was, borderline scurrilous. It was frankly so scurrilous that there was a subsequent civil suit brought by the natural mother of Lisa that resulted in a $15 million judgment against Attorney Steinberg, and that was appealed to the Intermediate Appellate Court in New York, which is called the New York Supreme Court Appellate Division. And in upholding that award of damages, the court noted that at trial, Steinberg had dismissed the 8 to 10 hours between the beating and Lisa's death as at most 8 hours of pain and suffering. He states that she experienced a quick loss of consciousness, and the court, mentioned that 8 hours to 10 hours could hardly have been quick. A truly tragic story, a truly remorseless person from all the evidence we've heard, and disbarred without a defense. Joel Steinberg, and we'll relegate him back to where he rightfully belongs. And so our next gentleman for discussion, and the last one for this hour, is Michael Avenatti. And I do this with some reluctance because I've met Mr. Avenatti. He is, or at least at the time was, a resident of my own hometown, and had quite a respectable and storied career in his early years, and by all accounts is a decent father and a decent man. I know of no evidence to the contrary. One will sense a trend in looking at some of these discipline cases of people who flew too high, kind of like the Icarus of mythology, flew too close to the sun, and that may have been Mr. Avenatti. A lot of very high profile, very well regarded, and no doubt very skilled lawyers get into trouble for one reason or another. I would suggest that Mr. Avenatti's entry into the political arena, his involvement in the Stormy Daniels case, for those of you who missed it, a woman who accused President Trump of improprieties before his presidency, and his attempt to put himself out as a candidate for the presidency of the United States, stating that he wished to run against either Trump or Pence, not anybody else. Avenatti started his career in Los Angeles. He was a lawyer at the very fine firm of O'Melveny and Myers, a long-time Los Angeles firm. It goes back over 100 years. Worked with some very well-known lawyers at O'Melveny. He then joined the Green Broylette law firm, which is one of the premier personal injury firms in California. And then he formed his own office, Egan and Avenatti LLP, in 2007 in Newport Beach. He brought many high-profile cases and lived a lifestyle commensurate with the sort of high-profile plaintiff's attorney that is well known to all of us who practice law, and probably to many people who don't. Avenatti had a huge victory in a case involving hospital gowns against the Kimberly-Clark Company. He got a $454 million verdict in 2017. Was reduced to $21.7 million upon appeal, but it was quite a high verdict originally. And then he had a 80-point-some million class action settlement against Service Corporation International, which is the company that's one of the largest companies in the funeral business. Avenatti was a Ferrari driving amateur race car enthusiast, real hard charger. That sort of comes across in his physical demeanor. And you don't get the kind of success Mr. Avenatti had by being an idiot. Unfortunately, he got a bit over his skis, likely financially. There were disagreements involving Egan Avenatti's finances. He began to be accused starting around 2017 of dipping into client funds. In 2018, his firm was tagged with a $10 million judgment by the United States Bankruptcy Court. He defaulted personally on a $440,000 obligation to pay back taxes. And then there was an allegation around 2018 of theft from his partner at the time. There was also an allegation that he'd converted $1.6 million of client funds that had been paid to him, as attorney for a settling claimant, and then not paid over to the client. And in June of 2019, the State Bar of California filed a 573-page petition to place Mr. Avenatti on involuntarily inactive status pending resolution of all the criminal charges against him, and probably of the opinion that given the precarious nature of the financial circumstances as found by the bankruptcy court, and given the allegations of misuse of client funds, and misuse is a generous term, that it was unsafe for the public for him to be engaged in the practice of law at the present time. And that is his current status the last time I checked. Really pushing Mr. Avenatti over the ranks into somebody who I would mention in this program, because ordinarily, like I said in the beginning, I wouldn't do it unless there was at least some actual conviction beyond mere allegations. Well, Mr. Avenatti was convicted following a March 2019 arrest in New York. He and another Los Angeles prominent plaintiff's attorney, who, through a miraculous divine intervention or for some other reason not publicly disclosed, has managed to elude prosecution on the matter. He was arrested for attempting to extort the Nike company, threatening to make a public disclosure of the fact that they had allegedly paid kickbacks to student athletes for endorsement of their products, specifically high school basketball players. He stated he'd be holding a press conference the following day, and it would bring a scandal upon Nike and that sort of thing. Well, Avenatti picked the wrong law firm to target with this demand. He met with them, as I might have said, personally in their offices in New York City in March of 2019, and it's reported that that law firm followed that meeting very quickly thereafter, like the same day thereafter, with contacting the United States Attorney's Office for the Southern District of New York, and they intervened and did their investigative stuff, which presumably involved audio taping at the very least. And ultimately, and I want to make sure I have this absolutely right, because he is, as I said, a living figure with a family. He was indicted on those charges. He was subsequently convicted on the specific charges on 3 counts relating to attempted extortion of Nike. And I would say this, that I understand that the conviction occurred. I understand the laws that were charged. I also think that any scholar on the issue of legal ethics could actually make a debatable case that what he did not constitute extortion. I think it's an extremely fine line, and we shall see how the courts ultimately treat it, and we shall see what the ultimate judgment of history passes. But there are a number of the people we talked about today where the misconduct is firmly established in fact, and the cake is fully baked. I don't think that's necessarily the case with Mr. Avenatti. Thank you for your time. Thank you for all your attention. There will be a part 2 to this program. I have no shortage of subjects. Some of the audience are members of a jurisdiction in which not 1, but you guessed it, 2 hours of ethics are required. So if you enjoyed this, or at the very least found it tolerable, I'll see you again shortly. Thank you for your time.